It's Shaya Lewis-Dermody here. I'm bringing you this webinar on the new DV laws in family law matters that are affecting the cross-examination by self-reps in family law matters. New law that's recently come in. So this webinar will go for about an hour. It's going to be fairly detailed, so I'll try and keep it quite interesting for you. Let me put up the slides. Here we go. So for those of you who don't know me, I'll just start with a little intro. As I said, my name's Shaya Lewis-Dermody. I'm the principal solicitor of the Family Law Project, which is a family law firm based, well, we're everywhere really. We've got clients around Australia. We've got offices in Adelaide and also in Perth, but we've got clients all over Australia. So most of the work that I personally do is independent children's lawyer work. I've been practicing as a lawyer in this jurisdiction for about 17 years, and I feel quite passionately about fixed fees and offering clients fixed fees and a more accessible service. So enough about me. I am going to start getting right into it. So at the outset, lawyers love caveats. Yes, we do. I'm talking about family violence today. I'm very mindful to acknowledge the use of gender neutral language where possible. I also know that this topic can be quite upsetting, particularly for men, around men being victims of family violence, and I acknowledge that men are. Look, the statistics say, and what we know is that it's largely women who are affected by family violence, but I want to acknowledge at the outset that men also fall victims of family violence. And what I've got there on the screen is a picture of my Adelaide team with an artist there. It's a 64, it's called 64 collection. And what it is, it's 64 portraits, which my office has purchased, by the way, and we're putting in our office. And each face represents the murdered, the person murdered through family violence each year in Australia. So 64 people. But the reason I put that there is it's not just females. So a number of those portraits as well are men who also are murdered as a result of family violence. Obviously, this is not specific legal advice. All lawyers give that caveat. This one's important about this being a sensitive topic. So I had one client, for example, who registered for this webinar, and she's a victim of family violence, very, really bad family violence, rape and so on. And I said to her, look, I don't want you to watch this webinar because there's nothing that I can't already, the information I'm acting for you, so I can give the information to you. And I'm just concerned about it being a bit traumatic perhaps for you to watch it. So in those circumstances, she's not. So look, if you need to stop watching this webinar at any time, please do so, or reach out for help if you need to. And so just moving on with my slides. Caveats continued. So this webinar in particular, today's webinar is going to focus on the new cross-examination laws in family law matters. I recognise that the system, the family law system, is severely flawed. There's many flaws of this system, and usually what happens is when I start talking on a topic like this, there'll be all sorts of comments from people about, oh, what about this, or this isn't fair, or this, the system's not fair this way and that way. I get it, that's fine, and I recognise the system is flawed. There's a lack of legal aid funding, there's a lack of community legal services, there's a lack of DV services, there's a lack of men's support services, there's all sorts of things. The court structure's not fantastic in my view. There's all sorts of things that are wrong with the system, but that's not what this particular webinar is about. So what I want to focus on today is the new law, the new law, perhaps the flaws with that new law, the loopholes, there's funding issues. So I'm going to talk about the intentions behind the new law. I'm just going to change the slide. And you can see there that this next slide is actually one of the paintings from our 64 portraits. So throughout this webinar, I'll have a few of these different pictures there, and they're not just, pictures that we've got off the internet. These are actually portraits that were painted by an artist and he sold that to us with all the funds going to a family violence service. So just felt really appropriate to include those pictures in this presentation. So that's what you'll see throughout. What I'm going to cover in this webinar is the intention behind the change in the law. So the reasons why has this law been introduced. I'll talk about what the law actually says. I'm mindful that most people watching this are not lawyers, although some of the information will be very relevant for lawyers. So for example, this webinar was really targeted at community legal advisors, for example. They need to be on top of what the law is. But I'm going to keep the legalese to a minimum because I'm mindful of the target audience is probably more so self-reps, okay? I'll talk about the practical effects and tips of the law change, and then some ethical sort of dilemmas and questions towards the end of today's webinar. So that's sort of how we're going to go. The gist of the new law, if I can put it that way, is essentially when somebody is self-represented and there's been allegations of family violence, they'll be prevented or precluded from cross-examining the other party. Now, what I'm going to do, I'm going to use, instead of alleged victim and alleged perpetrator, I'm going to use the terminology victim and perpetrator. So again, it's a use of words for convenience. So I'm very mindful that there are matters where there's false allegations made, for example, in court, and that's why we call someone an alleged victim or an alleged perpetrator. But for the purpose of this webinar, and for me to keep my words rolling, it will be victim and perpetrator, okay? So the new law says that the victim can no longer be cross-examined by a self-represented perpetrator. What the law also says is that it's a mutual order in that a self-represented victim is also prevented from representing the perpetrator. That's a very interesting part of it. So where did this law come from? So the Australian Institute of Family Studies did some, I'm just going to make myself a little bit bigger while I don't change the slide, did studies between 2015 and 2017, and they studied about 170, well, they made a finding that there was about 170 matters in the family law courts in Australia where the new law would be applicable. So where one or both parties is self-represented and where there's allegations involving family violence. Now, my view is that I find that number surprising in that I thought there would be a lot more than that. And I'm not particularly confident that it's accurate, but they're the statistics that the government has used when determining to introduce these new laws. So what we see in criminal jurisdiction, for example, so criminal jurisdiction in Australia is different in every state. But what we do see is that there's already these sort of, these limitations in place in that a perpetrator, for example, for a rape trial is not able to cross-examine a victim. And even in, for example, Victoria Legal Aid, there's funding in place for the perpetrator to be funded for a trial proper, the whole trial, including the cross-examination component, so as to ensure that there's protection for what we call vulnerable witnesses. It's different in different jurisdictions. I'm aware of another jurisdiction in the criminal spectrum where that assistance is very limited. There's no legal advice, and it's limited to being said that, look, perpetrator, you're not able to cross-examine the victim in the criminal court. And for that cross-examination component, we're going to read a list of questions essentially put to the witness. So the lawyer just steps in and is putting those questions to the witness without giving the perpetrator advice and so on. So it's different in each state. But this is the sort of thing that's been in place in the criminal jurisdiction. And we're now looking at this rollout into the family law jurisdiction. So what I want to do is I want to just play a very short video. Doesn't go for long. I'm just Before I do that, I just want to say is that the reason behind it is it's pretty obvious, I would think, in that the reason behind the amendments to the legislation is so as to avoid further trauma to the victim. It's further psychological abuse. You can imagine how traumatic it would be if you've been a victim of family violence to then be examined by your perpetrator in a family law court setting. Absolutely abhorrent. But what I want to say is this. I've had matters, in fact, I had a matter earlier this year, a very long trial, about 7 days, and my client was a victim of rape. That's her evidence, and the perpetrator was represented. So it wasn't him personally cross-examining my client. It wasn't him doing the cross-examination. He had a solicitor there. He had a barrister there. The barrister's doing all the cross-examination. He's still in court. The perpetrator's in court. So my client turned her back completely. She refused to face that direction. She found the experience completely traumatic, even in circumstances where he was legally represented. So she went off in the break and was vomiting. She nearly collapsed at a different time, a different day. It was completely traumatic for her. And that's putting aside the perpetrator himself directly cross-examining her. So even removing, my view, even removing the perpetrator from being able to personally cross-examine, you're still in a situation where this is a bloody traumatic experience, okay? So what I want to do now is I just want to play this quick video. It's of Senator McGowan of last year when this bill was being introduced into Parliament. And she tells the story of Eleanor, and Eleanor kind of inspired her, I guess, around having these laws introduced. And Eleanor was a victim of violence and was going through the criminal law courts and then onto the family law courts as well. I'll let Eleanor's story speak for itself. And bear with me, I'm just going to get this video going.
Eleanor writes, I am someone who has had direct experience with escaping a perpetrator of violence, then having to deal with the complexity of the system in keeping myself and my children safe from the abuser. My ex-partner was sentenced finally after 5 years this last January. Throughout the last 5 years, I've been subject to intense system trauma, both via the Victorian system and the federal family law. So Eleanor goes on to tell the story of what happened to her in the intervening years. But the bit I'd like to read into the Hansard tonight, the criminal system and civil system for intervention orders and the family law system are not aligned. Navigating your way through these systems is complicated, emotional draining and, dare I say, dangerous. After a contested hearing, I, Eleanor, was granted an intervention order on the grounds it was not safe for me to have my perpetrator near me. I remember looking over to the mantel in the room where a quote by Henry VIII was in pride of place. He too was a rapist. A week later, I was back in that same courtroom for family law proceedings. I was sick to my stomach to discover on day one of the hearing that he, her previous partner, had become a self-litigant and was going to be directly cross-examining me. That day I stood on the stand and the federal court allowed him to directly cross-examine me. It was a massive slap in the face. How could they give my rapist his power back over me? He asked questions I was forced to answer. He was only metres from me. How could this happen when another magistrate had already said that this circumstance was not appropriate or safe? It is this system flaw that I was able to identify as a major flaw, an obstacle in my recovery from trauma. Having your rapist stand only metres from you, asking intimate and personal questions about your relationship, your parenting, your social media account, every aspect of your personal life is invasive, disempowering and cruel. This person does not deserve the right to cross-examine his victim. She goes on.
Okay, so I think the story of Eleanor speaks for itself, really, and there's not really much more I need to add to that in terms of the effect that she felt being cross-examined, the very traumatic experience that it was for her. I think that's pretty much self-explanatory. I'm just going to put my slides back up. Okay, so just moving on. So we've sort of gone on to the reasons behind the amendment. So here we can see here, replayed psychological damage, another nightmare for victims to relive, being re-traumatised. And I've put there as well, being traumatic for children. Because that's what we see from time to time. It can be traumatic for children knowing that their primary carer perhaps is going to court and talking about their spend time with the other party. The other thing I'd like to note here is that there is potential for the family law courts in Australia to use like a screen to protect a witness, or even have a witness, a vulnerable witness, in a separate room, separate courtroom. But my experience is that's quite rare, and I don't actually see that very often. So what I've been talking about here is how traumatic the experience can be of cross-examination, and that kind of nicely leads into the next slide. Is, well, if it's all that bad, then why do we have cross-examination? Why put people through that experience? And I can tell you, you know, as someone who's been practicing for a long time in this jurisdiction, I don't want to be in the seat of my clients or any witness in the family law courts. It's not pleasant, and it's not designed to be pleasant. It's in fact very unpleasant, and so why do we do it? So we need to be able to test the evidence. It's called due process. What we do see from time to time is fabricated or exaggerated evidence, and the only way to really test that is through cross-examination. And there are false allegations made from time to time as well. In saying that, I'm not just talking about family violence, and I know people feel very strongly about, you know, false allegations in family violence. I'm not only talking about family violence, I'm talking about the entirety of the evidence that we see in affidavit material. I acknowledge that sometimes I do see things fabricated. I act for clients where that's the case. Well, I believe that's the case. But that's not the focus of this webinar. I believe that everyone has the right to be able to cross-examine someone and to test that evidence, particularly when their character has been put in disrepute, okay? So that's why we have cross-examination. It's part of that process. Otherwise, we're relying on he said, she said affidavits, and that's not satisfactory in my view. All right, so why would you choose to be self-represented? Well, I'm not sure how many people choose to be. In my experience, there's 3 reasons why people may be self-represented. The first is means, and I've put the $, figure there. Legal fees can be prohibitive, and I was at a conference in Perth just a few weeks ago where the Chief Justice spoke of the statistics over the past few years, and what we've seen in WA is the number of self-rep litigants have gone up and up and up, and I suspect that's largely due to the cost of engaging lawyers in the jurisdiction. It can be prohibitive, and when you're looking at legal aid funding is also means tested. However, if you're essentially earning anything above unemployment Centrelink benefits, you're probably not going to qualify for ongoing legal aid funding. So I've worked for a couple of legal aid services in different states around Australia, and that's the way it is. So legal aid is very much means and merit tested. So I've said means, money. The second is merit. So someone might choose to be, or they might be self-rep, because they don't meet the merit testing for legal aid funding. And the third reason is choice. And that's the third option that I struggle to understand a little bit. I'm not sure why someone would choose not to be legally represented and instead decide to do it alone. However, I respect that, and it really is, in my view, it should be someone's choice to be self-represented should they choose to do so. People have all sorts of reasons. So legal costs, lack of access to justice, lack of community legal services, that all comes into it, and that's another webinar topic altogether. All right, so next slide. So what's the official title of the new legislation is? I've put it up there on the slide. The Family Law Amendment, Family Violence and Cross-Examination of Parties Act of 2018. That's quite the mouthful, okay? That's what it's called. It commenced on the 10th of March 2019, came into effect September 2019, and it's essentially inserted a new division. It's called 102NA for those who are legally minded. It's essentially inserted that into the Family Law Act. So that's the technical, some of the technical. So 102NA, Family Law Act. Are we playing with fire? It's interesting. So I was interviewed by ABC Radio last year at around the time this bill was being circulated, and I raised a number of concerns during that radio interview around how is this going to work? You know, how technically is it going to work? It's a complex jurisdiction. How's the funding going to work? I can't see any, at least decent lawyer just stepping into a family law trial and choosing to cross-examine a witness just for that component. Family law trials are very complex. There's so much preparation needed. In my view, it would be negligent, and I certainly would not be putting my hand up in terms of my practicing certificate to just go in and cross-examine. It's a very complex area, and I just could not see how that's going to work. So next slide. So I'm going to keep this simple, and I aim not to lose you here. So hang on, hold on for those who aren't perhaps legally trained. What exactly does this new law say? 102NA is what I'm always talking about. I'll just call it the new law. So what does this new law say? So what it says is that it only applies to cross-examination matters. So what we know is that it's very rare for there to be cross-examination on in the interim stage of proceedings. So normally the cross-examination takes place at the pointy end at a final hearing at trial. So this new law applies to that pointy end, to where there's the trial only, okay? This is interesting. So it applies for that matter only. It applies if a party intends to cross-examine. Now, I don't know anyone who would not intend to cross-examine. So if you do not, it's very rare to see, if you choose not to cross-examine in a trial, you're essentially taking that witness's evidence as unchallenged. So I don't know why you would do that, particularly if you're wanting to dispute something in the evidence or really get into the evidence. So yeah, I find that interesting. The new law applies as a mutual order. So it applies to both victims and perpetrators, or I should say perpetrators and victims who are self-represented. That's key. That's really important to know. So if you're a victim of family violence, then this new law will probably, well, it will apply to you. The new law applies when there's an allegation of family violence. And then I'll put on the next slide, which shows us the circumstances when it's mandatory and when the new law definitely applies. So it's going to be mandatory if there's been a conviction or charge of violence, so not just an intervention order, a conviction or a charge of violence. It's mandatory if there's a conviction or a charge of a breach of an intervention order. And it's interesting, I was speaking to one of the judges in the eastern states, and he said to me that majority of matters in his docket, in his particular court, did capture those types of matters. where there had been a breach of intervention order. So that was quite interesting. So yeah, just going back, so it's where there's a conviction or a charge of violence, a conviction of a breach of the intervention order, a family violence order, like an AVO against both parties, so not just one. So they're the three. And then when it's also going to apply is where there's some injunctions. And again, I've referred to the legislation there. Don't worry so much about those sections of the Act. But I've put up here on the next slide to give you an idea on the type of injunctions where it's going to be mandatory. So these are injunctions that are made by the family law courts, not criminal. These are often injunctions that we seek early on in the proceedings, like on an interim basis, usually where there's allegations of family violence and we want to stop the perpetrator from going to the school or to the, someone's place of work or to the family home. Also injunctions where we're looking at property and we're looking at a sole occupancy order. So there you can see, sorry, I just got ahead of myself. So for the personal protection of a party to the proceedings, personal protection of a child to the proceedings, and it includes entering property, occupancy of matrimonial property. And it's just so important to know this, that these injunctions that we seek as lawyers regularly on an interim basis in the proceedings might set off those mandatory declarations that mean this new law will come into effect. It's going to trigger it. So if you're advising clients, you really need to keep that in mind to work out whether or not it's in your client's best interest to be seeking these type of injunctions at any stage of the proceedings. You just need to take every matter case by case. And I've put there the slide non-mandatory. So I've just listed off all the circumstances where it will be mandatory and where it will automatically come into effect. Now, the law actually refers to non-mandatory orders as well, and it's so broad. It basically says the court can make an order that the mandatory requirements apply, so discretionary. And I had a matter like that. In fact, we were the first in South Australia in that matter to have a non-mandatory declaration made, and that matter we acted for the victim, and there was family violence there, but we didn't meet those mandatory criteria, but we did an application in a case. We sought the order from the judge. The other party was self-rep, and that order was made. Now, I've had another matter which is non-mandatory, and in that matter, I act as the independent children's lawyer. One of the parties, the perpetrator, she has been self-represented with many lawyers throughout the proceedings, on and off, very much on and off. We're now at what I call pointy end trial. She's self-rep. It's causing lots of difficulties having a self-rep litigant in the court, and the court took it upon themselves to make this declaration. None of the other parties made the application. It's non-mandatory. As independent children's lawyer, I did not support the declaration being made because I knew the flow-on effect in terms of the mother having government-funded lawyer. And the critical part of that matter is that, violence was not, how do I put it? It wasn't one of the main issues in the proceedings, in that I actually could not remember the allegations of family violence at all. It's a very complex matter, and there's so many different issues going on, and it's very unlikely we'll even hardly touch on any sort of allegations of family violence at trial. So that was a circumstance where the judge called the matter on. The judge made this discretionary non-mandatory order, even though me as independent children's lawyer said, well, actually, I don't agree with that. Interesting. Anyway, so mandatory is mandatory. So I set out those mandatory requirements before. Essentially, if you've met those requirements, then the court must make the orders. There's no option. It is what it is. Okay, next slide. So what is the impact? The impact of a declaration being made or the order being made is very much this. If the self-represented examining party does not have a legal representative, then they will not be permitted to cross-examine the other party. That's it. I'll say it again. If the self-rep examining party does not have a legal representative, then they will not be able to cross-examine the other party. Now, what I've done here of these two pictures from our art collection, male and female, these mutual orders will apply to a victim and a perpetrator. Male, female, doesn't matter. But the point is victim and perpetrator, not just perpetrator. So even if there's a victim who's self-represented, they're also going to be precluded from cross-examining their perpetrator, which is interesting, I think. Yeah, sorry, I'm just looking at my notes. Just move this slide to the next slide. Show me the money. All right, so that said, and what we know is that barristers are very expensive. They're very good at their job. Who's going to pay for this? So what barrister is, I've already said that me as a solicitor wouldn't be putting my hand up to go into court purely for the cross-examination component. So what barrister is going to be putting their hand up to have a very ill-prepared brief? Barristers need to be instructed directly by solicitors. So in effect, it would mean the self-rep not only needs a solicitor, or not only needs a barrister, but also the solicitor is the middle person. You can't directly instruct a barrister. Very expensive. So show me the money. Who's going to pay for this? I've already said that the reason that most parties self-represent themselves, self-rep, is because of means, money, or merit. So what we've got, enter the Family Violence and Cross-Examination of Parties Scheme. You can see it there on the slide. So this is funded by the Commonwealth Government. Legal aid is different in every single state of Australia. This Commonwealth funding is completely separate from legal aid funding. Okay, it's a scheme set up by the Commonwealth Government, and they've put aside $7 million for the next 3 years for this scheme. I don't know if that's going to be enough, to be honest, based on the amount of matters that we're seeing that are captured under this new law. Even though it's not funded by mainstream legal aid services, it's going to be, well, it is now being administered by these legal aid services. So it's a grant of legal aid, but it has nothing really to do with legal aid, if you can think of it that way. Now, I spoke informally to a judge a few months ago, and he, from the eastern states, and what he said to me, it's effectively free legal aid, which is not means or merit tested. Free legal aid, which is not means or merit tested. That's how he has described it. So free funding for the self-represented party, male or female, and to both parties if represented. So I've looked into the different legal aid commissions around Australia, and I'll just run through them very, very briefly, because I know that everyone listening is from different parts of the state. However, I'll just touch on it briefly because it's interesting. So Legal Aid New South Wales, they provide full training for lawyers to be able to be part of this scheme, 2-day training. You need to be on a panel. And what the Legal Aid New South Wales says is that the funding will cover both preparation and the actual trial. So preparation is often the big thing, particularly in Sydney. I've worked in Sydney as a lawyer, and private fees in Sydney are enormous, definitely upwards of $5,000 for trial preparation. And that's not even going into barrister fees and so on for the actual trial. Now, Victoria Legal Aid, VLA, they're saying that the grant under the scheme only covers the cost associated with preparing and attending hearings where personal cross-examination is likely to occur, and they want it to, well, they aim to have it in place, a lawyer allocated at least 6 weeks before the trial. It suggests to me the preparation component will cover document preparation, trial affidavit preparation, which is the big bucks. Legal Aid WA, interesting, have said that their view is that it only covers the cross-examination component only. Now, I've already said the shortfalls of that, and as a lawyer who also works in Perth, I certainly won't be taking part in just cross-examining someone in court. I think that's very risky. The other thing in Perth or WA is that they say, or they take the view that it only applies to married couples and not de facto couples. Well, I also find that quite remarkable, because family violence certainly is not limited to marriages. That we know that for a fact, that's for sure. So I do think that's wrong, and I do think the intention behind the legislation is that funding should occur from the date that the declaration is made, that the order is made by the court. In South Australia, they acknowledge, look, we'd been in discussion with the government for 18 months or so. We recognise the shortfalls that I've kind of talked about today so far. And ultimately, they decided that it would be fair and best practice to have a fully funded scheme, and that will fully fund someone for trial, including trial preparation. And it's as of the date the declaration has been made. So we've got some matters in South Australia where that's been made and the trial's not listed for 6 months' time, that sort of thing. We had one the other day. The declaration was made. Our client was eligible for funding. Trial was going to run the next month. Trial was vacated and has now been pushed off and off and off. That funding has remained in place. So interesting. I don't know what's going to happen there. The other thing in my conversation with Legal Aid in South Australia is that their view is that it will also likely apply to property matters, which is unusual because mainstream legal aid, it's very rare to fund property matters, particularly for ongoing proceedings in court and or trial. That's usually what we see for funding for property matters in all the states, is maybe dividing debt or just super splitting, even if someone's got a house, it's unlikely to get ongoing legal aid funding for the property matter. So just let me quickly summarise. Next slide. I'll make that a bit bigger. So the summary, it's not means or merit tested. In most states, it's not limited to just the cross-examination component in the family court, and it's not necessarily limited to parenting matters. Yay, property settlement. So yeah, the property settlement one, that's really important for lawyers to know as well. So if you've got a lawyer, make sure you run this past them and see what your lawyer has to say. So 26. Hooray, free access to lawyers, but seriously. So seriously, the couple of seriously I wanted to mention, so I think my office is now up to 5 matters where we're involved with people, at least one party being eligible for the funding under this scheme. My office is a small component of the Australia-wide matters going through the family law courts. So it's quite remarkable. I feel like the budget's probably going to blow out. But anyway, so a couple of examples I gave was the client we've got funding for and the trial was vacated and will be listed next year and funding stayed in place. Another example is I had a client years ago on a private basis and he could no longer afford to pay my legal fees. Lovely guy. And I just touch base from him from time to time, every 6 months to go, oh, hey, is your matter still in court? Yes, it is. Poor guy. And he's really lovely. And he's now got the declaration made by the court because there at some stage must have been the mandatory provisions were kicked off. So he's now got funding under the scheme because he never qualified for legal aid. He earned too much, but not enough to qualify for legal aid. So we're now acting for him. So yeah, there's these different examples. There's another client who has been paying privately but can't afford the barrister fees that have been quoted for a trial next year, and she's likely going to have to go self-represented because she just can't continue paying privately. And we're aware that she's likely to qualify for funding under this scheme once she's self-represented. So yeah, just that they were just a couple of interesting examples that my office has had. So I suspect there's been lots. So what do you need to do if you're a party or a lawyer? You might need to file an application in a case if it's non-mandatory. You need to, if you're a lawyer, I would suggest reviewing all of your files and to ascertain which ones may fall under the mandatory or non-mandatory provisions. And you may need to contact legal aid. If you are, I'm just going to have a drink, just excuse me. If you are in receipt of legal aid, mainstream legal aid, or if you have a client who's in receipt of mainstream legal aid and the declaration's made, the order's made, then you should be contacting legal aid to have your funding transferred to funding under the government scheme. So the reason I say that is, for example, in South Australia, what I've been told is that if we're acting for a victim of family violence and the perpetrator's self-rep, the perpetrator, the judge makes the order, the 102NA order, the perpetrator then qualifies for free funding under the scheme. So we're acting for the victim. So our victim is in receipt of mainstream legal aid funding. We want to switch her to the government scheme funding. And the reason for that, there's a few reasons. The first is when you're in mainstream legal aid funding, everyday legal aid, there's a cap, there's a limit as to how much funding you're entitled to. Generally speaking, there'll also be a statutory charge, a stat charge on your certificate of title for your property. And what that essentially means is that when you go to sell or transfer your property at a later date, you ultimately have to pay back legal aid. And albeit it's a lot less than paying a private lawyer, but you still have to pay it back. And also mainstream legal aid is merit-based. So if you are able to get yourself or your client on this government schemed funding, so if the other party's on it, then you should also be on it. If you get yourself on it, you won't have the cap issues, you won't have the stat deck, and you're not going to be you're not going to be merit tested either. So we often see clients who are refused mainstream legal aid funding because of merit. Sometimes we disagree with that. But if they're eligible under this other scheme, then merit's not an issue because merit doesn't play a part in it. And then this slide, the writing's quite slow, but what my office did, we had a meeting to discuss these new laws, and we had a bit of an ethical session where, as lawyers, and support staff, we put these questions to each other and just had a bit of a conversation around it. I don't have the answers to these questions, but I do know that they're relevant questions to ask, and that as lawyers we have a responsibility to be thinking about this at least. What I've put there is, should parties be forced to obtain legal representation? So what I'm saying there is, if you're the perpetrator, why should you be forced to obtain legal representation, and why shouldn't you be able to represent yourself? Likewise, as a victim, if you're a victim of family violence, why should you be precluded from cross-examining the perpetrator? If you choose to, then you should be able to. These are questions. Then the next thing there is I've put, so this was kind of targeted towards lawyers, just being mindful of those injunctions that I spoke about that we often get early on in the proceedings around personal protection of a parent or a child, not to go to education, not to go to the school, not to go to the house, occupancy of the home, sole occupancy, and so on. So as lawyers and as a party as well, you need to consider, well, do you start seeking those orders early on in the proceedings on an interim basis if you know it's going to trigger off the mandatory order? So they're just things to think about. Next slide. Okay, so if you've got a private client, or if you are a private client, either the perpetrator or the victim, do they stop instructing your law firm knowing that the mandatory order will kick in and they'll be eligible for free funding? So that's really around advising clients that, look, you're paying us privately, but we're aware that if you stopped paying us privately, you're actually eligible for this free legal funding under this Commonwealth Government scheme. So I'm not advising lawyers or clients to take advantage of that, but what I'm saying is that clients and parties have a right to know of that opportunity if it exists, and that I feel that as legal advisors, we have an obligation to be transparent with our clients about that as well. So that's for private clients trying to get off the financial wheel, trying to get some free funding under the scheme. So, and then we had the discussion around legally aided clients. So if you're on mainstream legal aid, do we then go self-rep? Do we suggest you go self-rep? Or if you're legally aided, do you go self-rep? If you know that your mainstream legal aid might get cut off for merit reasons, because legal aid is means and merit-based. Funding under the new scheme, merit's not an issue. These are just thoughts, okay? Last one is around the issue of the trial listing and the timing of the listing of the trial. We know that once an order is made for setting the trial, it's likely the declaration is made at that point to say that anyone self-rep is precluded from cross-examining. It's likely at that point that the order is made. So do we early on say, yep, let's get a trial listing now, knowing that the provision will kick in? Or is it in our interest as a party to the proceeding, or our client's interest, to delay the listing of the trial to try and delay that kicking in? So, for example, I might be acting for a victim and the perpetrator's self-rep. I want to avoid them getting some free legal aid funding, so I push back the trial listing so as to avoid this potentially free legal funding coming into place. I hope that makes sense. Okay. Alrighty. Now, for this last slide here, what I've done, so because what I've gone through can do your head in a bit, right? And that's not my intention. I've tried to avoid legalese as much as possible and keep this relatively simple for you, whilst still drawing, hopefully, your attention to what the issues are with the new law, the good and the bad. And I've perhaps found some loopholes there and certainly outlined some concerns. What I want to do is bring this back. So we're coming to an end now. I just want to bring this back to the story of Eleanor. And that's why I've put this last slide up here. And I'll make it a bit bigger, actually. I'll reduce me so you don't have to look at my mug so much. I want to bring it back to the story of Eleanor and the intention and the reason that these changes in the legislation were made. So despite the flaws, despite the concerns that many of us have about these new provisions, the intention is important and really goes back to what a traumatic experience it is for a victim to be cross-examined by a perpetrator. What a crap situation. Please remember that. That's the intention of the law. My view is that there's many shortfalls of the family law system, and there's so many different ways that we can make improvements so as to avoid this. And like I said, cross-examination by anybody, not just your alleged perpetrator, can be traumatic. So that's my opinion. But let's just finish in thinking of that story of Eleanor, or the story of anyone who's been a victim of family violence. So yeah, guys, look, thanks for your time. I really appreciate it. It's we're just on 50 minutes now, so if you've hung in there, good on you. I appreciate it. If you want to give me any feedback, good or bad, bring it on. My email address is there. Details of my law firm is there. We service clients all over Australia. And you can instantly book a phone appointment with one of our lawyers on our website. That's all from me. If you want to get in touch with any different webinar ideas, I'd love to hear from you. But otherwise, thanks so much for your time. See you later, guys.